Seated. Sir, what's with the camera?
I'm news media.
Remove the camera from the courtroom. Right now.
She's an individual process server, but I'm Christopher King, and I run the website Mortgage Movies. It's an old card. And yeah, we have a vested interest in maintaining the integrity of the system and allowing reporters and First Amendment privileges in this courtroom.
Okay.
That's right.
Thank you.
That's what we do.
Just because the court might not throw out large press from an event like this, it doesn't reduce their responsibility that's incumbent on them to cover a case like this, because this is a case involving prior restraint, unlawful prior restraint. And this means that there was no compelling governmental interest for the court to do what it did. There's not even a rational basis for the court to handle things the way that it handled. We're here with King Cast Mortgage Movies, and obviously we're at the Superior Court here in King County, aptly named. We're going to be suing Judge Stanley Rumbaugh of Pierce County.
Okay.
We'll be suing Judge Stanley Rumbaugh of Pierce County. We're suing him here. The venue's appropriate here. We're going to then go serve him in Pierce County after I file here in King County. And that's the deal. So come on in. So this is the lawsuit. We have the complaint here. And then following the complaint, of course, we have interrogatories, request for production of documents, and of course, after that, the request for admissions. And he has to admit that he didn't follow the law in General Rule 16, because you're supposed to hold an inquiry when you bar or consider barring a reporter from a courtroom. You have to do that. And the presumption is in favor of access, and Judge Stanley Rumbaugh failed to provide that access, and then failed to provide a rationale, and he told my colleague Wally Brown to get the camera out, get it out now. So you know what? He's got to get sued now. It's a ridiculous state of affairs in this country right now, and I won't have it. Wasn't raised that way. I was taught that constitutional considerations still prevail in this country, and, well, frankly, we're going to see if that's true. I'm almost next. No, we are almost next. We the people are almost next. And we're back. We're now in Tacoma. I believe His Honor is in 2A, which I believe is coming up right here. Courtroom's 2A. Rumbaugh.
As you watch this, please be aware that some folks have asked whether His Honor might try to duck service because it was left on his bench instead of being hand-delivered to him. Well, first off, I was concerned that he might order me arrested, given his prior attitude and conduct. And second, I figured he'd be a fool to try that because he might lose, and plus it would just cost the taxpayers yet more money in this case. Money which shouldn't have to be spent in the first place, were it not for his actions. So he's at fault ab initio, and nothing will ever change that. So we're just doing what we have to do to correct the situation. Anyway, please just read the case law I've submitted here, showing you unlawful prior restraint decisions from the East Coast and from right here in Washington, for that matter. It is patently evident that Defendant Rumbaugh has run afoul of the legal principles derived in those cases. Stay tuned.
Ma'am,
Yes?
what's the name of the company?
There's no company on the process server.
What is your name, please?
She's an individual process server, but I'm Christopher King, and I run the website Mortgage Movies. It's an old card. And yeah, we have a vested interest in maintaining the integrity of the system and allowing reporters and First Amendment privileges in this courtroom.
Okay.
That's right.
Thank you.
That's what we do. I think His Honor is familiar with the fact that I was running my own videos in my own trials 20 years ago, so I continue to do that, and that's what this case is all about. Thank you.
Yeah, a minute ago you had asked me about the role of major press in all of this, and I think, I responded by saying, hey, well, I was major press, well, let's say mainstream or larger press, because we're all major press. No one is larger, or no one is more or less major than the other. That's the key here. And so, just because the court might not throw out large press from an event like this, it doesn't reduce their responsibility that's incumbent on them to cover a case like this, because this is a case involving prior restraint, unlawful prior restraint. And this means that there was no compelling governmental interest for the court to do what it did. There's not even a rational basis for the court to handle things the way that it handled matters with Wally Brown or with me or with the third plaintiff, which we'll get to. But in any event, there was no compelling governmental interest for the court to do what it did. And even if there was a compelling governmental interest in prohibiting reporters from being in the courtroom, this was not the most narrowly tailored approach to do so, nor was it the least intrusive means by which it could have done so. There are statutes in place to govern this, where the camera should be, all kinds of things like this are all spelled out in General Rule 16, which the court ignored. The court did not make a specific finding of fact as to why Mr. Brown should not be allowed in court. So now we have three plaintiffs. We have Mr. Brown, who was thrown out in court, as you saw in the previous video. You have me, because I wrote in a notice of media coverage that was ignored. And you have Christopher, I think his last name is Newby, who's a citizen who has a derivative First Amendment right to view the news the way he wants to view the news, as long as there's someone willing to provide it. Okay, so the judge said, defendant Rumbaugh had said, oh, well, the court reporter is here to take down the official actions of the court. Well, that's a total non sequitur. We know that there's a court reporter there. We're not there for that purpose. We're there for another purpose, Your Honor. And it's a purpose that's going to be discussed in court, and I'm going to break it down. I'm going to tell it to you just how it is. I will bear no compunction to do so, just as you bore no compunction to illegally toss my brother from that courtroom. And that's it. And, I'll see you in court, Your Honor. I'm tired of this shit. Ooh, this is not my America. It's not what I learned in law school. It's not what I've learned my whole life. There's no way to be. You just don't throw reporters out just because you don't want them there. It's bullshit. Oh, I'll take that.
Your Honor, with all due respect, are you kidding me? I have been running courtroom video, even with my own trials, back 20 years now, 1996, 97.
The jury in this case, being duly impaneled and sworn, find the defendant not guilty of the offense charged. The events of this day, Van Doyle, is it like that? Complete.
Is it like that? The guy didn't shake my hand. Rob Tobias.
Thank you, Your Honor. Yes, thank you, Mr. Speaker. Going to get my BMW out of here.
And I have seldom, if ever, seen the course of conduct by a judge as unprofessional or as demeaning as yours. So you know what? You're going to put it out there the way you think it is, and now Mr. Brown and I and the community are going to put it to you the way we think it is, and the way that GR-16 specifically calls for it, that you specifically violated. And you also violated the First Amendment to the Constitution. So, the federal Constitution and the state Constitution. So, I'm not going to have any of this from you, okay? We're going to have this in court. Everything that happens in this case is going to be televised on YouTube and beyond. And there's not a damn thing you can do about it. I don't care if I have to get a decree from God. I will not tolerate this abuse from the judiciary. We pay you to do better. You have a moral and ethical and legal obligation to do better than that.